You mentioned that being one that your law firm is an international firm with a seat in London. And so one question, you can answer it in any order you want, is if you were asked to be a sole arbitrator in a dispute involving one of the targeted Russian entities, what would your reaction be? Would you immediately accept it and then also notify your insurer that you want to increase your insurance? And so that's one question. The second question is, do you think there could be some kind of argument that if the sanctions are going to affect the ability of parties to be able to have counsel of choice, that this could have impact on the right to counsel, which is a protected human right, which perhaps then comes in competition with the trade sanctions, and then which interests should be rated higher? And related to that, and the first question is, we all know that the appointment of your arbitrator is one of the important protected rights of arbitration. And should that be considered when taking into consideration the trade sanction effect on the appointment of the arbitrator?
Alistair, this is the revenge of the Academia of the Practitioner.
Right. Let me start with the first one. What would I do if I was asked to accept a sole arbitrator appointment in relation to a case between potentially sanctioned Russian entities? First, I can answer that as a process. Whenever I am approached to accept an arbitrator appointment, I have to run a full conflict check procedure through my firm, which is a worldwide process. And amongst other things, it will alert me if any of the names involved in the conflict search are sanctioned anywhere in the world. I'm now going to give you the cop-out part of this answer, because if that happens, I'm required to refer it to other people in my firm who have to decide what I do. Now, there is an interesting point about all of this in arbitration terms, which I'll come back to. But the answer is I would not automatically accept that. I would ultimately be subject to other people in my firm who control our work for sanctioned entities as to whether or not I could do it. And if they say I can, I will. And if they say I can't, I won't. But observe, if you would, that that procedure involves a number of other people becoming involved in whether I can accept a confidential appointment between two parties to arbitration, and arguably goes way beyond what is appropriate in terms of the confidentiality of the arbitration proceedings. After all, there are all sorts of other people in my firm who now have to look at that question as to whether I can act in relation to a specific party, in relation to a specific matter. I don't believe that that is problematic, but at a very purist level.
But leaving aside conflict issues of your firm, and you have no conflict, I think that would be quite interesting too. I mean, what kind of process and how would you look at the matter?
Is it similar to the same kind of process that you might have when dealing with anti-money laundering legislation, and you have these designated people who are given a greater identity check? Yes.
We do have quite a lot of complication in terms of accepting instructions in relation to the underlying parties. And the way we deal with it, which I think is the same as the way many international law firms deal with it, is rather a cop-out, if I'm honest with you. We open the file in the name of the institution rather than in the name of the underlying parties. Therefore, our client will be treated as the Kuala Lumpur Regional Centre for Arbitration, and we don't have, therefore, money laundering obligations in relation to that client. Now, I believe that that is what most law firms do, most international law firms, from my conversations with people, but I'm aware that it is something of a cop-out.
Interesting. Good tip for all of us.
I've just remembered that Dato Sandra said that this proceeding was going to be recorded. So I should just like to clarify that everything I've said is in fact not true, and we exercise rigorous control. There were two related questions then on a party's right to counsel and
right to appoint its arbitrator.
And a right to appoint its arbitrator. And it is clear, I suppose, that the impact of sanctions law is to restrict both of those rights. It is potentially necessary for counsel to decline to accept those instructions in their own interests, and it is potentially going to be necessary for individual arbitrators to decline to accept those instructions. I don't think, anyway, people have a wholly unrestricted choice of counsel or of arbitrator. There are other reasons why counsel may cease to act, including that they don't like the reputational the reputation of the particular client that's seeking to instruct them. There are reasons why tribunal members don't accept appointments. For example, that they don't think, under the particular rules, that they're going to make enough money. You know, there are many international arbitrators who will refuse to accept appointments in some of the regional institutions around Southeast Asia, not including Malaysia, simply because the fees are so small that they're not interested in those appointments. So I don't think that right to counsel of your choice or right to an arbitrator of your choice means a right to demand that every conceivable individual will accept that position. But insofar as the state does restrict that ability, then arguably they are interfering with basic rights. But I observe this: if a state passes a law which says that the chairman of a tribunal has to be of a nationality other than that of the parties, they are in some sense restricting the right of the parties to choose an arbitrator. If they were to say, and I don't think anybody has done, that a party-appointed arbitrator couldn't be of the same nationality, would people say that that was in some way a breach of a fundamental human right? I can see the argument. I'm not sure that it's ever played out, as far as I'm aware, in practice yet. It will be fun to watch if it does do.
Okay. Question, contribution from the floor, comments? Arranged in all days event, not just about the seats and all that. Yes.
Kind of question for Alistair. That's okay. You were talking about how Malaysia has the potential to be a seat and there's an opportunity right there. Do you think it has more to do with the fact, because I believe that the traditional seats got there as well with the economic activity that was backing it, and the reason Hong Kong and Singapore is so popular is because they're literally not given a choice. There is some sort of pressure from the economic activity that has a bearing on the institution of choice. Would you think that's true, or would you think an institution has the potential to stay out there on its own?
Look, there is no doubt that Malaysia starts further back in the field. Okay, I mean, I don't think I'm talking out of school to say that. It has to make up some ground. And you're right that part of the reason that, for example, Singapore is a global arbitration center is because it also is a major economic center. But more than that, it has regional headquarters of corporations there. It has international law firms there. It has the infrastructure for international arbitration there, which encourages people in turn to say, let's have the arbitration here, rather than go somewhere else. Which is why I think those in Malaysia who are seeking to open up the market here to all of the players in international arbitration in a rather more liberal way are working in the interests of the KLRCA to be a more assertive regional arbitration centre, because then all the service providers and the participants and stakeholders in the process can come here and will be more invested in KL as a centre of arbitration. I don't want to veer into political areas, but I will say this, that in recent years, the progress that Kuala Lumpur has made as a global centre of arbitration is extraordinary. From so far back in the field, it's really become a serious, credible international player now. And I can say this now without being accused of sucking up because Sundra is not here. It's a lot to do with Sundra. He's done a remarkable amount to push this institution forward, and all credit to him for that and for his very able colleagues. I think there is every possibility that Malaysia can become a serious, credible, global player in that same top-tier bracket. But to do so, to really achieve, it's going to have to do more than simply promote itself. It's going to have to make some changes to the market as well.
Boris, could I have a quick comment from you?
No, I would agree with everything that Alistair has said. And I would say also, I mean, you know, as Datuk Sundaraju, you know, one of his favorite stories is he always says about the power of marketing. The story of how Singapore ended up on the BIMCO form as one of the standard options. You know, it tells the story of how they literally camped outside the door of the session until they caved and added Singapore. So, you know, never underestimate the power of sort of pushing your way in. But no, Alistair is exactly right, and there are certain elements of the market that are not available here in Malaysia as yet. The availability of legal services, I think, is one of the major ones. It's no coincidence that a lot of international lawyers fly through Malaysia on a regular basis to see their clients, because the clients don't have access to them here. We see them all the time because they come and visit us at KLRCA. Having access to those lawyers on the ground here in Malaysia is something that is really necessary to push it to the next level. But it's a process. I mean, Charles and Hamlin, I think, got the first foreign law firm license not long ago, I think about a month ago. It's still a little bit restricted, but it's a step in the right direction. And, we'll watch that with eager eyes.
I think Patricia mentioned something about, the promise of the East. Maybe you can make a comment there. The promise of the East must be backed by robust institution. I remember you saying in the course of the day. I don't know whether in this hall or in coffee break. Would you want to make a comment on that, Pat?
Well, I'm not quite sure what comment. I did make a comment. I'm not sure if that's the one you're relating to, that a colleague of mine, or friend of mine, Professor David Wilkins at Harvard Institute for the Legal Profession, that studies the legal profession and is world leading in that. He says that, he quotes Kurt Vonnegut, who said that lawyers should be like pilots. Pilots, when they're flying, are always looking for a place to eventually land. And lawyers should always be looking for a place where money changes hands, and that all the world indicators of every sort indicate that money, if you want to be where the money's going to be in the next 30 years, you have to be in Asia and Africa, because the US and Europe are having a declining role in the world GNP, declining role in innovation, et cetera. So this is the place to be. And I think you need, as an institution, if I look at the SEC institution, we're celebrating 100 years in 2017. And 30 years ago, its caseload didn't look at all like it looks today. You have to be in it for the long haul. You don't build up a reputation. You don't build up your name in arbitral clauses overnight. It's a long, long-term building. And I think I'm really impressed with what I've seen here. You have, obviously, not only do you have a great leader with vision, but like any great leader, he knows how to surround himself with a great staff to implement his vision and to contribute to it. And the facilities are fabulous. It seems that your legal infrastructure, we heard that today, from all the different aspects of it, are all pulling in the right direction. So it seems like you're well positioned. And one thing that I think that makes this particularly promising is fantastic hotel across the street, really nice, at what must be a fifth of the price of Singapore. So that the cost of arbitrating here is of a different character than the cost of arbitrating in Hong Kong and Singapore. And that can be something quite important. Time and cost in arbitration are something which are very, very much discussed. When you have arbitration, and you have to have 3 or 4 breakout rooms, and you have to have hotel rooms for experts and for co-counsel and for parties and fly them in. Having a airport that has a lot of services, having an ease of bringing people in without visas, having good communications, that you can do video conferencing, that you can have inexpensive conference rooms. I think that makes this a very competitive market, and especially if you can start to build perhaps on the cases where the clients just don't want to pay Singapore, Hong Kong prices. I bet you got lawyers in your office that would be willing to come here. So I think that market there helps to build your experience and reputation.
Well, since we also have a Middle Eastern person here, I was thinking of asking you to make a comment.
Okay,
yes.
thank you.
You can comment on any part of the discourse. Yes.
Well, yeah, I wanted to mention that I've heard and I know that arbitrators are being paid in Singapore. I mean, they are tax-free when they are getting the arbitration cost. So I think this is an option that Malaysia also should consider.
We have the same here. We have the same already here.
You do have?
Yes, yes.
So international arbitrations here, I mean, the income of the arbitrators, the payment of the arbitrators are tax-free.
Correct.
Okay, perfect. So no more comments, all right?
Doctor, I'd be interested to hear from your perspective as someone who works in an institution in Iran, some of the practical difficulties that you encounter as a result of some of the issues that we've discussed today.
Maybe we ask Dr. Yara to say something first, right?
Yeah.
Before you respond to a specific question.
Yeah, I agree that the facilities are very impressive here. Starting from this center, from this building and the hotel as well, the costs are much lower than in Singapore. And currently I only have a Belarusian passport. I haven't received my UK passport yet, and I need a visa to go to Singapore, so I had to go to the embassy, apply, and I didn't need a visa to come here. The other thing which I think can make a difference is that you are located in a very nice tourist destination. So it's easy to, let's say, to go to the beach, to the islands. And if you can package it, let's say, as a short course for lawyers from, I don't know, from Moscow, from St. Petersburg, Kiev, from whatever, so that they can do, let's say, an intensive training in arbitration here for 3 days, and then they can, spend, 3 days on an island, or maybe you can even have your training there. That can kind of create more interest in coming here, because I would rather, let's say, if I were a Moscow lawyer, I would rather go to here rather than to Stockholm, particularly in winter. So that's another thing which you can explore, like short courses. And I know that ICC has even a special academy for lawyers from the former Soviet Union. So every year they have classes in a new jurisdiction. And I think SCC also has events, marketing events, seminars for people coming from that particular region. So if you want to become more visible, to become more recognizable in that part of the world, I think that's the way to organize trainings, to bring people here, to use the geography as well.
Thank you. Very practical tips. Faris, you were asking a question about the Iranian experience of building.
Yeah, I was curious as to some of the practical experiences and issues that you've dealt with as a result of sanctions and what we've discussed today.
Well, generally speaking, I don't see any practical difficulties for conducting an international arbitration in Iran. There might be some problems with the enforcement, of the arbitral awards in Iran, because some courts are not still very, very familiar with international arbitration matter. But, well, what we can, for example, claim, what I can complain right now is that this negative reputation of Iran being engaged in sanctions and nuclear program, media are expert just to exaggerate everything and just to show a picture which is so not true. So I can point out this problem as a difficulty. It happened to us that many times international parties were reluctant to come to Iran just because they had a negative, idea that what's going on in Iran. A few years ago, I was about to go to Afghanistan to teach a number of Afghan students, and before I went there, everybody was warning me that, are you going there? It's dangerous and people might kill you. And I went there, and I was in Kabul, and I said that, well, everything is fine and nothing, and there is no danger. And later, it turned out I had the same experience with Iran, that I heard that people say, okay, how is the situation in Iran? Are you safe? Yes, it is safe, and everything is going well. All you need is just to come and see, and to be persuaded that no problem exists there. Well, we can provide all facilities for conducting international arbitrations in global level in Iran. And we have all the facilities, and you can simply acquire an Iranian visa, so you can simply arrange for conducting the arbitration. And I'm saying the only problem might go to the setting aside the arbitral awards sometimes, or enforcing.
As I eavesdrop in this conversation, I think Dr. Sundra and his team and many of us in friends of KRC, we call ourselves friends of KRC, believe in this big word called collaborative work, right? We collaborate with institutions, and even in the presentation of Faris stroke Sundaraju, you can see that there's continuous reference to other institutions. There are no desire of KRC to say that, KRC is the only place, come here, right? Really, institutions building is a shared enterprise, right? And this inclusivist vision, if I may use that word, is what binds and has a special Malaysian flavor, we would like to say. Hence, when I started the poem just now, there's no sense of being anti-West, although this discourse has a sense that the Western imperium has been, rather strong. There's a sense that we can have a coexistence and collaboration with institutions and building institutions and robustly pursuing this enterprise together. I wonder how the other panel members feel about this point that I'm making, and maybe a short bite response to that from Alistair first, maybe. Do you agree that kind of a more collaborative kind of a...
I like that notion.
Yes.
But I think that the world of institutional arbitration is now a highly competitive international market.
Good reality check, yes.
And I think institutions are fighting for market share of the international arbitration work that is out there. And although I completely agree that it is desirable for institutions to cooperate together, at the same time, I think that they would knife each other in the back as soon as they could if they could increase the amount of work that they would get. I overstate it, but you take the point.
A real politic check. Yeah. I think realism is important in this conversation too. Yeah. Faris, you want to say something?
I don't entirely agree. Actually,
Okay,
a lot of the jurisdictions that I mentioned here in Asia that are setting up institutions and that are looking to increase their capabilities, it's not with a view to increasing their caseload or really hearing cases at all. We found that much of it is just internal capacity building. They just want to actually have the knowledge. They see that international arbitration, not just commercial arbitration, but also investment arbitration, is something that they will not be able to avoid, something that they will have to play the game, so to speak, and therefore they want to have people within their jurisdiction that actually know a thing or two about it. And we find that has fueled the growth within ASEAN at least, far more than any desire to have a commercially successful center. And I can say from KLRCA's perspective, I mean, we're perhaps less commercially driven than Singapore and Hong Kong by virtue of how we're set up. We're sort of more of a almost like a community center. So we undertake projects, sports arbitration, which we had a whole day conference a couple of days ago. We will not likely see any direct commercial benefit from that for many years. It's essentially like a domestic national service. But KLRCA is footing much of the bill for that. We're looking to establish mediation in the medico-legal industry here in Malaysia, and that's to try and increase harmony within what is at the moment a slightly damaged medical industry in Malaysia. Again, mediation, not a big commercial venture that's likely to bring much direct gain. So we undertake these sort of projects. Islamic finance arbitration as well with Bank Negara. As I said yesterday, we have no qualms with those rules being used overseas in arbitration seated overseas. In fact, that's probably likely that's how it will be used mostly, which will not bring any direct benefit to KLRCA by way of case numbers or financial benefit. But it just means that it's a service that we have offered and a value that we have added to dispute resolution around the globe. Perhaps that's by virtue of how we're set up that we are able to do that.
Actually, it's fascinating, a slight rejoinder to Alistair, but maybe the two is not dichotomous, right? Competitiveness is part of the givenness of the market for institutions to succeed in the marketplace, and that gives us a discipline. But collaborative or cooperative ventures or knowledge capacity building, which KLRCA is part of the DNA. I mean, this wider debate of whether it's a Darwinian survival of a fitness and selfish gene of Richard Dawkins, or is it a cooperative gene that there is a sense that it is not wholly dichotomous. I mean, I'm venturing into a discourse that is somewhat far away, but I think I like this discussion. I think this is part of the conversations we're going to have. I want to just share something realistic. Yeah, I mean, I was part of some of these regional forums, and I won't mention the country, and there was this rise of Asia, and there was this huge panel, and KLRCA was not invited to be part of the rise of Asia. And some of us think, how come? Well, surely the rise of Asia, KLRCA, though a minor player, though a little bit late off the block, though we were quite early, but we didn't build the capacity, was not even invited to be part of the rise of Asia. And my response to that in a private conversation is, we don't need to beggar your neighboring competitive institutions. we could work together still. The market is wide enough, and we should not have this sort of a huge dichotomy between competition and collaboration. But this conversation is realistic and it's good to take place, right? Any other comments? Well, I think if not, I think it's a good time to stop, all right? I mean, there's a place. Oh, Dr. Zain, okay. Couple, make it two, all right? Not three, right?
First of all, thank you very much for organizing this conference. It's been very informative, and I really enjoyed being with all of you here. My question for Faris, because you've mentioned that the KLRCA is considered to be a diplomatic entity. So the arbitrators, where they're conducting arbitration under the umbrella of KLRCA, would they enjoy diplomatic immunity? The reason I'm asking you these questions because at the Gulf countries we have what we call it the Gulf Cooperation Council for International Commercial Arbitration, and it's considered to be a judicial body. So the arbitrators during an arbitration process in the center will enjoy judicial immunity. So do they have similar situation here? My second question for you guys, and sorry to be blunt and frank, Malaysia is considered to be a Muslim country. I am a Muslim myself, and I've lived in Australia, like you, and I'm become an Australian citizen. So always the West, they have a different perceptions about Islamic countries. And to be honest with you, this is my second time in Malaysia. Before, 5 years ago when I came here, I said, what's this country like? Are they very strict? So this is why people now, they prefer Singapore, because Singapore is well known to be an open, free country, where when you try to compete with Singapore, even Iran, for example, I know it's very safe, but people straight away, they say, Iran is a Muslim country, they're gonna, you know, it's not very safe for you. On the social media, I've been following a case recently, it's not related to arbitration, but where they execute Australian citizens who have like a Chinese background or because they smuggle drugs to Indonesia, which is very fair, this is the law, but on the social media, if you see the response from Australian citizen who's never been out, it's a corrupted system, how can they do this? So what's if they smuggle drugs? But you see, so people, this is an area I think if you wanted to promote Kuala Lumpur as an international city and a hub for international arbitration, you have to work on the image of the country, try to provide more confidence in the system that it's a fair system, there's no corruption, so if you come in, it's very safe. And this will take a little bit of time, but with the awareness you're doing now, I think you will get there. Thank you very much.
Well, there seems to be more nature of a command, all right? And I think we can leave it at that. And it's a very, very fascinating issue, right? The issue of Islamic polity versus the whole Asian feeling, multiculturalism, and globalized Asian. I don't want to have the last word on this matter. But I think since everybody is here, I want to, since all the panelists who are available here, I want them to say something that is in their heart about today's proceedings. You could also respond to that if you like. If not, say something, just 1 point or two, and then we go down the list, and then we close the session. All right? Doctor, want to say something?
Yeah, I think I was impressed both by the country and by the institution. Now, I do a lot of work in Sri Lanka, so I thought that it would be a bit better, but it's miles better. So it's, no, I mean, the country is, from what I can see, I think is ready, and the institution to become a major center, and so it's mature enough in my view.
Thank you for the encouragement. Dr. Obis?
Thank you. I have no more comments to add, just to, thank KLCRA for providing this opportunity. And also, I wanted to thank ANQUA for all the issues before the conference. Thank you very much.
I think the future are the people, the stakeholders, and the institution needs to be supported and serving the stakeholders. And from my very brief and experience with the stakeholders that I've met here, and the lawyers, institutional employees and such, I think that you have a great stakeholder base, a great collaborative future. So with that, I think you have all the resources that you need if you all work together and pull for that.
Faris, can you comment first before Alistair? the last but not the least of them.
No, look, having been involved with the organization of today, I think the day has wildly exceeded my expectations in terms of the depth of the discourse that we've been able to enjoy and the quality of the speakers that we've had and the quality of the presentations has been really phenomenal. And I hope it's something that, as a center we can continue to do in terms of, being a thought leader and leading these kind of discussions.
Alistair?
I'm going to be cheeky and make two comments.
Please.
Firstly, and I'll leave you to decide if this is a metaphor or not, I said to Sundra at lunchtime that I love coming to this building, although a lot of the work I do is at Maxwell Chambers in Singapore, because this building, although it has equal facilities, has a lot more character and a lot more heart than Maxwell Chambers, which is in some ways rather sterile and soulless.
Soulless. Yeah.
That's my first comment.
Right. Whoa, right.
And my second comment is this: it would be most remiss of me not to say thank you to everybody who has allowed me to be here today, and I really, really appreciate that opportunity. Thank you.
Well, I started off with Kipling verse and I'll end with that again, but for those of us who don't care to read poetry, it's interesting, all right? There was a Kamal, there's a colonel, and they were fighting over a steed, and they were fighting over borders, and towards the end of it, there's this lovely closure. Ha done, says the colonel's son. Put up the steel at your sides. Last night ye had struck at a border thief, tonight is a man of the guides. Well, arbitration is about guiding hostile parties together and seeking a resolution institutionally, whether it's the bully in the football field or the drone that is being sent elsewhere. We try to say that if we, in common humanity, and the panel itself has shown such diversity of views, both robust realist of Alistair, and aspirational ideal of Faris, and the mediated statement of Patricia and Doctor. We thank everybody here, and I just want to say that it has been great to have you in this audience. You have been listening, participative, and that is great energy for everybody. So we want to say Selamat Jalan and Selamat Malam, and thank you so much, and good day. Bye-bye.